How do you get your driver's license back after a lifetime revocation in Oregon? Welcome to the RestoreYourRights.com questions and answers video series by Lorkey Law. I'm attorney Jesse Lorkey. What we're talking about here is a lifetime driver's license revocation that occurs after a person's had 3 DUIs in a lifetime, and in some other cases where a person was seriously hurt or injured in an accident. The relevant statute for what I'm going to be talking about is pretty much all contained in Oregon Revised Statute, or ORS 809.235. In this video, I'm going to talk briefly about the eligibility requirements for getting your driving privileges back, what the considerations are that the judge has to consider by statute, and briefly about the procedure that you have to follow in order to get in court to get the judge to sign that order to give your driving privileges back. The message I want to get across is that these restorations happen every day. I talk to a lot of people who are intimidated about whether they're going to be able to get their driver's license back, but the truth is that by the time you meet the eligibility requirements that I'm going to talk about, you're probably in good shape to make a good case to the judge. So first off, eligibility. The first requirement is that you have to be at least 10 years out from the date of conviction. And that's the date of conviction if you were sentenced to probation. If you were sentenced to parole, usually meaning that you were sent to prison, then it's 10 years from the date that you were released on parole or post-prison supervision, which usually means that it's 10 years from the date that you got out of prison. Other requirements are that if you had your probation revoked, it's 10 years from the date of the revocation, and significantly, you have to be 10 years out from the most recent driving conviction. So I talk to a lot of people who've had a driving while suspended in the last 10 years. And if you've had any kind of criminal case that shows that you're driving, you're not going to be eligible until 10 years from the date of that conviction. A driving violation does not count under the statute, but it's definitely going to play against you when it's time to prove to the judge that you're rehabilitated and the judge sees that you had driven against the court's order to not drive. So ideally you have no driving offenses in the last 10 years, but for strict eligibility at this time, the requirement is that it has to have not been a driving crime, and we have actually been able to get a driving privileges restored for a person who had had a driving violation in the last 10 years. Now, I'm recording this video in February of 2022. The Oregon legislature is in session, and we're expecting a bill to be introduced that will reduce that 10-year wait time down to 5 for purposes of a hardship permit. So stand by on what's going to happen with that, but that will be a great requirement. I talk to a lot of people who are very rehabilitated. They're raising families. They need to be able to drive to work, to take care of their parents, whatever the case might be. And they're not in danger anymore. It's been a whole lifetime ago since they were revoked. Reducing this time is going to be a good common sense fix for a lot of Oregonians. So after the time for eligibility, the second requirement is that you must have completed a treatment program that's approved by the Oregon Health Authority. Now, you're required to do this only if treatment was ordered by the court, which is almost every Dewey case. The judge just automatically orders treatment as part of probation. But I've seen in a couple of cases where a person went to prison and the judge figures a prison and the parole officers are going to take care of that, and there's no requirement for treatment written into the judgment just to comply with your probation or parole. If that's the case, you don't have to make that showing. The statute doesn't require it. It's not that it's a bad idea, but it's not a strict requirement. So we always order a judgment to make sure that we're complying with what the judge had ordered before. Now, this Oregon Health Authority requirement can be a problem. If you did inpatient treatment, it does not qualify as a Dewey program. And likewise, if you went to a veterans treatment program, it's likely not going to qualify. The Oregon Health Authority requirement for Dewey's is that the program be outpatient, that it have random urinalysis tests, and accountability as part of the treatment program. Now, I've worked with a few people who have been sober for 10 years or a long time, but they never did a treatment program. and they have to go back in order to meet the requirement and do a treatment program even though they're sober. So that could be something that you have to do if you find yourself in a situation where you didn't do treatment but it was ordered by the court. It doesn't matter if you completed that requirement while you were on probation. Obviously that is best if the probation just went perfectly, but if it didn't, you're not out of the running at all, and it works out just fine. Another requirement for some people is a psychological evaluation. Now, the statute says that the judge's decision needs to be based in part on the recommendation of the parole officer, which shall be based in part on a psychological evaluation that's ordered by the court. Now, what that sentence means is that a person who's on parole, meaning that they got sent to prison, parole or post-prison supervision, almost always means that the person was sent to prison, but not entirely every time. If you had a parole officer, you're required to have this psychological evaluation requirement, which is its own entire extra onerous kind of requirement. The psychological evaluation has to show that the person's not presently a danger to the public. But if you were on probation, which is the majority of cases, not sent to prison, then you don't have this psychological evaluation requirement. In order to grant the driver's license restoration, the judge must find by clear and convincing evidence that the person is rehabilitated. Now, this rehabilitation finding comes after the judge has decided that you meet all of the requirements. And the requirements are very black and white. There shouldn't be any question about that. So if you're getting into court, it should be on the question of whether you are rehabilitated. And you have to prove that by a high standard, clear and convincing evidence. The way I think of it is that it's our job to prove to the judge that the judge is not going to look stupid or end up in the newspaper for giving a person their driver's license back, that this person is a safe bet to put on the road. To prove a fact by clear and convincing evidence, Oregon law says that we have to show that that fact is highly probable. We have to show it's highly probable that you are rehabilitated. And this is done in large part by showing that it's been 10 years since you've had any kind of trouble. Ideally, a person, no matter what their criminal history is before, if there is a significant change at the last DUI, then we're well on our way to making that showing. If criminal activity per your record continued on for some time, we can deal with that. We're looking for a significant time of change to be able to show that a person's rehabilitated. Ideally, a person is sober, they've quit drinking or using drugs, whatever the problem was leading to the DUIs. It's not a strict requirement though, and we've definitely gotten through driver's license restorations where a person socially drinks. They need to show that they've got this under control, and it's probably going to take witnesses to do that. So the judge's consideration is going to be based on witness testimony, the testimony of the petitioner, and in some part on any exhibits that are submitted for the court's reference. Exhibits might be a certificate of treatment completion, and it can also include the certificates from work, new licenses, new degrees, things that show that a person has moved on from the point where they were getting in trouble and getting DUIs. That all goes towards showing that a person is rehabilitated. Now, to talk briefly about the procedure for getting your driver's license back or your right to apply for a driver's license. You file a petition in the circuit court in the county in which your driving privileges were revoked. That means that if you are prosecuted in a municipal court, for example, the Eugene Municipal Court, which is located in Lane County, then your petition gets filed in the Lane County Circuit Court, likewise with whichever county and city court that you might have been dealing with. And you have to pay a court filing fee. It's currently $281. The petition has to be served on the district attorney, and like I said, there shall be a hearing. Judge can't just sign this based on the pleadings. And depending on the jurisdiction, that hearing's at this time is either going to be virtual or in person. Now, as a new civil case, it's not a criminal case. The person that's asking for their driver's license back is the petitioner, and the district attorney through the state of Oregon is the respondent. The district attorney is going to take a position. The best situation would be where they support. They actually are convinced on the pleadings that a person is rehabilitated. More often than not, though, they'll take no position. They'll stand neutral and just say they're willing to allow the person to make their case to the judge. And in some cases, the district attorney is actively going to oppose. No matter what their position is, you kind of have to prepare for the case as though it's going to be opposed because it's your burden of proof. You have to prove by clear and convincing evidence that you're rehabilitated. It's not up to the district attorney. It's not like in a criminal case where they have to prove that you're guilty. This is your burden. You're going to testify at the hearing, more than likely, and you might have witnesses testify. It's important to know that anybody who testifies is going to be subject to cross-examination by the other side, which is the district attorney. This means that they get to ask questions. They get to ask questions. Usually it's going to be about sobriety, about drinking, about drug use, about stability in life, whether a person has support systems. I've heard a lot of questions about whether a person's involved in Alcoholics Anonymous. These aren't requirements, and what's nice about these is by the time you're doing it, if you've gone in and been honest in your petition, then you don't have any worries about what the questions are, and you can answer them without too much worry. Your criminal record, the history that got you here, is a decade in the past, and you're proud to show how well you're doing today. Now, when you make your case and the judge signs your order restoring your driving privileges, what they're restoring is your right to apply for your driver's license with the Department of Motor Vehicles. It does not restore your license. You still have to go to the DMV and meet all of their requirements. There are the knowledge test, the driving test, the reinstatement fees, and the getting your driver's license back fees. Also, the DMV is going to require that you have a SR22 or future financial responsibility insurance for 3 years. You have to have that on your car before you can take the test, before they'll give you your license. And also, a ignition interlock device is required to be installed for 5 years. And you can't get your driver's license back until you have a car that has the ignition interlock device and the SR22 insurance. So that's a quick overview of the current law in Oregon. I hope this video was useful. If you have any questions, give us a call, 541-357-6788, or visit us on the web, restoreyourrights.com. It's easy to schedule a free attorney consultation. This is the restoreyourrights.com video questions and answers series. I'm attorney Jesse Lorky. Thank you very much for watching. Goodbye.